Hi, everybody. So we are going to be discussing Chapter 5, Civil Rights in this video. So I am going to show you guys the PowerPoint. We'll get started right into it. It's a much shorter chapter than civil liberties. So there's still a lot of really great information, but it won't be quite as long or in depth as civil liberties is. So chapter 5 starts on page 118 if you're following along in your book. So this picture is something that's happening actually here in Florida, or was happening. So in 2018, Amendment 4, which is a ballot initiative to restore voting rights to former felons, passed in Florida thanks to the efforts of Florida Rights Restoration Coalition and its executive director, Desmond Meade, who is pictured here. And so that is one based on the felon, or the felony rather, and whether or not like they've completed their sentence, their term. So whether that be prison time, probation, fines, community service hours, et cetera, once all that has been completed, and then if their felony qualifies, then their rights have been restored. So it's not for all felonies. It just depends on what it is. And if somebody's felony doesn't automatically qualify for restoration of rights once they've completed their time and are done with all of their reparations, then they can appeal the state to try and receive their voting rights back and to have their rights restored. Okay, so for this chapter, we have just a few chapter goals, not nearly as much as we usually have. So outline the legal developments of social movements that affected civil rights, explain how the courts have evaluated recent civil rights concerns, and explain the key Supreme Court decisions on affirmative action. So the definition of civil rights is the obligation imposed on government to take positive action to protect citizens from any legal action of government agencies and other private citizens. So remember what I mentioned in the last lecture or the lecture before, I'm not sure. Civil liberties is the freedom from government interference. Civil rights is the freedom to partake in the process without like retribution. So civil liberties is freedom from, civil rights is freedom to. All right. So all citizens, all American citizens have civil rights like off the top. And things are only taken away if it's, something like you've been charged, with a crime and it's taken away during that. So when it discusses discrimination in your book, which civil rights focuses a lot on, that chapter 5 does, it's talking about the use of any unreasonable and unjust criterion of exclusion. So that's like what we had with segregation and what we had with women not having the right to vote and marriage exclusions for people who are not heterosexual, those sort of things. So civil rights are definitely protected by the government and at all levels. So federal, state, county, city, et cetera. Your civil rights are protected, and you can, take a case to court if they're not, for whatever reason, like if they're infringed upon. So we talked about the 14th Amendment last lecture. And so that is what guarantees us to have the civil rights to us, not just what the amendments say that the government at the federal and state level can't do. It also guarantees like what is given to us. It's not just about restricting government, but about giving us guaranteed freedoms and rights that can't be infringed upon. So the 14th Amendment says no state shall make or enforce any law which shall deny any person within its jurisdiction the equal protection of the laws. So that's at the state and federal level that the 14th Amendment applies to everyone. So, and remember, we discussed how it had to be slowly, like painstakingly, slowly implemented across the board. At first, the states wanted to say that the 14th Amendment only applied at the federal level and for federal laws, and the Supreme Court has consistently said, no, that's not accurate, as they broke down the other amendments and said, no, the Bill of Rights applies to everybody. So the reason why that is the case is the Equal Protection Clause. It's the provision of the 14th Amendment guaranteeing citizens the equal protection of laws. This clause has been the basis for civil rights of African Americans, women, and other groups. So that's incredibly important to understand. Like the 14th Amendment, and specifically the Equal Protection Clause, is what has been utilized in cases time and time again to say, hey, we're not getting equal protection under the law, we're being discriminated against. And so that has continued to break down those discriminations that are occurring, as the Supreme Court has said, hey, the 14th Amendment applies for this as well. And then people are able to take that and say, hey, see, I told you, you were discriminating against me and that's not okay. And it helps to break down those barriers that antiquated thought processes within our elected officials at state and federal levels have imposed on people over the time of our existence as a country. So the first thing your book discusses with that is the abolition movement, which is to end slavery, of course. So the 14th Amendment was adopted in 1868, which gave civil rights being part of the Constitution. But it has definitely been an uphill battle to enforce it. So the caption for this picture says, "Slavery tore the nation apart and ultimately led to the Civil War. The abolition movement organized in the North and pushed to end slavery." Harriet Tubman, which is in the far left here, you can see her with the hat on, and she's holding something in her hands, was an abolitionist and formerly enslaved person who helped many enslaved people escape bondage through a system of safe houses called the Underground Railroad, which you guys should be really familiar with that term from your history classes before. She took great personal risk to continually help other people get free and to help them escape slavery and get to places where they would not be turned back over to their owners. And I use that because obviously nobody owns anyone, but that was the system that was utilized at the time, where they were viewed as property, not as their own people. This. So that was a really big deal, obviously. Slavery was widespread, especially in the South, prior to 1860. And the Civil War was about multiple things. You'll hear people say, oh, it was about states' rights. It was about slavery. Okay, let's not try and put lipstick on a pig. Okay, yes, states' rights to have slaves. Like, that was the biggest thing that kept pushing people. So you'll see in your book on page 121 and 122 that it kind of talks about the first enslaved people. They were in Jamestown in Virginia in 1619, a year before Plymouth was even established in Massachusetts. By 1840, nearly half of the population in Alabama and Louisiana were enslaved Black people. 1/4 of Southern white families were slave owners at that time. But in 1857, the Supreme Court inflamed the slavery controversy with its infamous decision in Dred Scott v. Sanford. Dred Scott was an enslaved person who sued for his freedom because his owner had taken him to Illinois and the territory of Wisconsin, both of which prohibited slavery. The court, however, ruled that enslaved people, indeed all Blacks, were not citizens of the United States, and that Scott was his master's permanent property regardless of where he lived. This decision split the country deeply and helped to precipitate the Civil War. From the ashes of that conflict came the 13th, 14th, and 15th Amendments, which would redefine civil rights from that time on. And those 3 amendments are known as the Civil War amendments. So that's really important to understand that, at the time, the Supreme Court, that was just sort of the way a lot of people thought and believed. And as we have seen in the last week, depending on who is on the Supreme Court, and I had mentioned this in the last lecture as well, determines their interpretation of the law. I mean, they literally are interpreting things based on their personal experiences, based on their legal background. And so it really depends on who's on the court as to how they interpret it. It's subjective, right? People say that the law is black and white, but everything is skewed. Everything in your life is skewed based on your own personal experiences and beliefs. And while people would hope that judges would check that at the door, it's impossible to check your entire life at the door, right? People aren't robots. So it's incredibly difficult for them to check their personal feelings at the door. And that is what we have seen this past week with overturning Roe v. Wade, unfortunately. And so now legislators are scrambling to try and figure out what to do. Some states are tightening down on abortion rights. Some states are expanding them to try and counteract, and to make it easier for people who are in states where it's not allowed for them to come to their states and do what they need to do for their own reproductive health. Congress has been trying to figure out a way to codify Roe v. Wade, which means to make some sort of law that would be blanketed across the federal level. But frankly, the votes are not necessarily there to be able to make headway. People have pushed President Biden to try and take some sort of policy action. There was a memo from the White House saying that there would be some policy legislation put out within the next week or so in response to the Supreme Court decision. So it'll be interesting, but Roe v. Wade has been on the books for 50 years. And now that the Supreme Court has shifted in its political leanings, it is a more conservative court now. They took it back. They reversed it. And a lot of people are concerned about the precedent that that's going to set. Justice Clarence Thomas even wrote a concurring opinion, which is basically additional thoughts that he has on the ruling that aren't necessarily other people's in the court, but his specifically. He voted to reverse Roe v. Wade, and then he also had additional thoughts where he felt that for the right to privacy, gay marriage as well as birth control should be revisited for the right to privacy. The court is presently, the majority of people on the court are looking to undo the right to privacy in many instances. You will absolutely see the ACLU, the NAACP, LGBTQIA groups all take on court cases, like of the first opportunity that there's any sort of discrimination, you can bet that there will be cases taken to court to strike down all of this, because we're moving backwards now in civil rights as opposed to forward. People have been marching about this stuff for 50 years, and now it's an issue again that women are having to push back on, that minorities, the LGBT community are having to push back on. So there's a large concern for that. There's also a large concern about the right to privacy for HIPAA and your right to having your health records protected, because how are you going to enforce a restriction on, say, somebody going to California and getting an abortion and then coming back to wherever their home state is that doesn't allow it? How are they able to even track that, right? So there's a large concern that they're going to be using digital markers, literally tracking your phone, tracking your text messages between people talking about getting it done, tracking apps that women use to track their menstrual cycles, and that sort of thing, like Flow, FLO, is the #1 used women's app to track their menstrual cycles, to track if they're trying to get pregnant, if they're, whatever the case might be. It's a widely used app for a lot of women for their personal reproductive health. And so there is now a concern about things like that being breached by the government, all to try and punish women for making a very personal reproductive health choice. So Flow, actually, the app has recently announced that they are removing, they like scrubbed their apps to where personal information can't be accessed, like names, date of birth, that sort of thing. So the government can't utilize them against women who utilize the app. And there's a lot of pushback, obviously, about the use of your personal technology to be used against you, and to violate your right to privacy. And remember what I said in the last lecture, you need to be concerned that a violation of anyone's civil liberties and civil rights is a violation to everyone's civil liberties and civil rights, because they might not be coming for you today, but they might tomorrow. So if you have the right to privacy still, what's to stop them from accessing your personal health records? What's to stop them from using that to discriminate against you for employment or disability or public services? What's to keep them from putting you in a box to exclude you from things as a result of violating HIPAA and your right to privacy with your medical health professionals and yourself? So people are very concerned about that, for good reason. So we'll keep obviously following that, keep an eye on it, be talking about it throughout the rest of the semester, as to kind of how things are going with those issues, as well as other things that are presently happening in the news. So we'll see. One of the things that a lot of people find interesting is Justice Clarence Thomas is a Black male, and he is married to a white woman. And it wasn't all that long ago when his marriage was illegal, and now he wants to go after gay marriage and make it illegal again, or a states' rights issue. And remember what I pointed out to you, that the book talks about that states' rights have largely been used in a racial and prejudicial manner, over the last several decades because it has been used basically against the people as a way to limit people's rights as each state sees fit. And people are saying that one's medical health should not be determined by their zip code. So that is the issue that people are facing right now. So, of course, when you talk about civil rights, like the first large issue is the abolishment of slavery. And then the next issue that was really focused on and marched on and pushed back against the government were women's rights. So women did not have a lot of rights prior to the Civil War. You couldn't even open your own bank account without your husband or your father signing off on it and being on the account with you. You couldn't buy land, you couldn't buy a home, you couldn't go to school. Like, you had to have some sort of male authorizing you to do anything. Like, women were children who couldn't make their own decisions. Don't even get me started about that nonsense. So that became like obviously a huge issue. So through the 19th century, American women were denied rights that are granted today. In most states, women didn't have the right to vote. And the doctrine of coverture gave the husband control over his wife's property. Lacking political and property rights, women in the United States were effectively second-class citizens. Less than 10 years before Dred Scott in 1848, the quiet upstate New York town of Seneca Falls played host to a convention that began the modern women's movement. The centerpiece of the convention, organized by Elizabeth Cady Stanton and Lucretia Mott, was the adoption of a Declaration of Sentiments and Resolutions patterned after the Declaration of Independence. The most controversial provision of the Declaration, nearly rejected as too radical, was the call for the right to vote for women. What? So, like, not just the right to vote, but that women could run for office and we could vote for them. Crazy thought, right? So that was obviously like a big push. And that was something that, we're talking from 1848 to 1920 before women had the right to vote. Oh, I'm so sorry. So that's what, 58, 68, 78, 88, 98, 8, 18. So 72 years later, women at that convention were more than likely not even around by the time women gained the right to vote. So it's just another example of how white men of prosperity originally and property, and then all white men tried to control everyone else out of fear of losing control of the system, right? If they could keep everybody else under their thumb and less than them, then they could stay in charge. And if you're a white male and you're annoyed by that sentiment, I mean, it's literally in your book. I'm not saying it because I'm a woman. I'm saying it because that's history. So, not saying that you are presently like that, but white men were that way, and a lot of them unfortunately still are. Not all of them, maybe not even the majority, but there are a chunk of men out there who still believe that they should, be the end all be all of everything. So after you started seeing like the push for an end to slavery and for women to be granted equal rights, specifically the right to vote, we had the Civil War, which I won't go into. We know what the Civil War was. We know who won. Of course, us living in the South, we all know that not everybody can let go of the fact that we lost. Lord Almighty. So after the Civil War, there were 3 different constitutional amendments that were added to the US Constitution that added to and redefined the civil rights that we had under the first 10 amendments. So the 13th, 14th, and 15th amendments were known as the Civil War Amendments. The 13th Amendment ended slavery. Done. It's really that simple. The 14th Amendment guaranteed equal protection under the law and the right to due process. So that was very important, right? We just talked about the 14th Amendment and how it guaranteed that for everyone under the law in a way that it hadn't before. And then the 15th Amendment guaranteed the right to vote for African American men. So now we're at a point where white men with land, all white men, now African American men, all have the right to vote. Still no women, white, black, or other, but all men had the right to vote. So there was a big pushback, which I'm sure you're familiar with in your history class, our history classes, with how the South was not happy with any of this. They were not happy with the ending of slavery. They were not happy with African American men being able to vote and also like run for office and that sort of thing. They were not happy with giving up that power and that control. So there was pushback from the people about that, and a push at all levels of government as well, because a lot of people who weren't comfortable with it were people in power. So there were some things that were created to stifle these amendments. So there were several laws created known as Jim Crow laws, which were laws enacted by Southern states following Reconstruction that discriminated against African Americans. So remember, Reconstruction was what took place after the Civil War. So it's like your Northern soldiers staying put, helping get things back on track, helping implement the changes, helping African Americans start running for office, helping them get registered to vote, helping them like be in this next stage towards equality. But, you know, after a while, you know, they've got farms, they've got families, they've got to go home. So when they went home, the South acted a fool, as we've been known to do, and really, really pushed back. And so these Jim Crow laws were implemented to make it much, much, much more difficult to achieve the equality that they were fighting for. So after these laws had been created, the Supreme Court enforced them with their decision in Plessy v. Ferguson. So Plessy v. Ferguson happened in 1896. There was a Louisiana law that required segregation on races of the races on trolleys and other public transit, and by implication in all public facilities, including schools. So Homer Plessy, a man defined as 1/8 Black. So he didn't necessarily like really look, you know, stereotypical or like, you know, but 1/8 Black, sat in a trolley car reserved for whites and was found guilty of violating a law providing for equal but separate accommodations on trains. The court held that the 14th Amendment's Equal Protection Clause was not violated by racial restrictions as long as the facilities were equal. Plessy v. Ferguson legally authorized whites' use of race to exclude non-whites and established the separate but equal rule that prevailed through the mid-20th century. Judges in this period generally accepted the false pretense that accommodations for Blacks were equal to those for whites. So it's basically the doctrine that public accommodations could be segregated by race, but still be considered equal. However, that phrase is a misnomer, right? It's false in its own statement, because if you're having to separate out people, then you're clearly saying the people who are not allowed to be part of the other are not inherently equal. This image says in the 1896 Supreme Court case of Plessy, v. Ferguson, my tongue is not cooperating, upheld legal segregation and created separate but equal rule, which fostered national segregation. I apologize. Overt discrimination in public accommodations was common. So, we had black and white water fountains and bathrooms and portions of restaurants and portions of buses and all sorts of public transportation and segregated schools and nonsense after nonsense after nonsense. So after World War II, Supreme Court enforced more strictly requirements of separate but equal. However, that kept getting pushed back. So in 1938, the court rejected Missouri's policy of paying the tuition of Black students at out-of-state law schools rather than admitting them to the University of Missouri Law School. In 1950, the court rejected Texas's claim that its new law school for Negroes provided education equal to that of all white University of Texas Law School, a ruling that opened the question of whether any segregated facilities could be truly equal. These and other cases strongly encourage Black leaders led by NAACP lawyers to confront the separate but equal rule head on. So Plessy v. Ferguson is decided in 1896. And then we're talking like 55, almost 60 years later in 1954, a Supreme Court case was put forth known as Brown v. Board of Education. So Oliver Brown, an African-American, had 3 Black daughters and they were in a racially mixed neighborhood. So there was a white school that was close by the neighborhood that those girls were not allowed to go to. They were required to trek across town to the Black school. And obviously that was not cool. And this is in Topeka, Kansas. So every school day, his daughter Linda took the school bus to the Monroe Elementary School for Black children about a mile away. In September 1950, Linda's father took her to the all-white Sumner School closer to their home and tried to enroll her in the 3rd grade in defiance of state law and local segregation rules. When they were refused entrance into the school, he went to the NAACP, and soon after the case, Brown v. Board of Education was born. So, and obviously other cases like this were happening across the United States. And so a lot of times what happens is those cases sort of like join together with cases like this as like additional proof of what it is that they're going to court for. And so that happened as well. So the Supreme Court, after they had been kind of slowly saying in the last 10, 15 years, maybe we're, looking at this wrong, like maybe these other things are not equal. And so when Brown v. Board of Education happened in 1954, the Supreme Court unanimously overturned Plessy v. Ferguson. Here's what they had to say. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. So states no longer have the power to use race for discrimination in law based on Brown v. Board of Education. The national government now had the power to intervene against discrimination that states forced onto their citizens. So if you happen to see it on anything, Plessy v. Ferguson allowed separate but equal. Brown v. Board of Education overturned separate but equal and said it is not equal because it's inherently unequal because you're separating people out. If we were really all equal, there would be no need for separation. So that's where that comes to. So it altered the constitutional framework by striking down separate but equal. And it also signaled the court's determination to use strict scrutiny in cases related to discrimination to be able to determine whether or not discrimination is being utilized, whether or not like there's a rule or a law that is hindering other groups of people. So the burden of proof would fall on the government to show that the law in question was constitutional, not on the challengers to show that the law was unconstitutional. So strict scrutiny is a test used by the Supreme Court in racial discrimination cases and other cases involving civil rights and civil liberties that place the burden of proof on the government rather than the challengers to show that the law in question is constitutional as opposed to not. So most states did not want to cooperate with these new laws outlawing segregation, but they didn't really get a choice. It was forced on them. So after this happened, of course, we're talking the South again, pushed back and we're like, no, we're not going to do it. You can't make us. There were a lot of schemes created to try to push back. So like paying tuition for white students to attend newly created private academies. Southern school boards began to eliminate their legally enforced school segregation, but a lot of actual segregation still remained. And that has to do with racially segregated housing. So you'll see in your book on page 125, de jure and de facto. So those are terms that de jure means literally by law. So segregation that's on the books, that is a law, that ended, okay, because of this ruling. And that was before the 1960s. So de jure segregation ends as a result of all of this that's come down from the Supreme Court. However, there's something called de facto, which literally means by fact segregation that continued because we had all the segregation happen. So what would happen is we'd have all white neighborhoods, all Black neighborhoods, some mixed neighborhoods, but mostly segregated areas. There were segregation and discrimination practices that kept Black families from being able to purchase homes in certain areas, and they would get turned down for mortgages. They get turned down for loans solely by the pigment of their skin, even if they met all of the qualifications. So that limited where they could effectively live and purchase homes. So what ended up happening is we had segregation that occurred just by the simple fact that segregation had occurred in the past. And so it sort of separated people into their own corners in their communities. So therefore, you would see certain schools have a larger white population or a larger Black population based on the neighborhoods, because now we're, okay, like where you live determines the school, not the color of your skin. So if your neighborhood is largely Black, well, you're still going to pretty much see Black kids at that school, right? And vice versa. So, and we, unfortunately, we still have that today, actually, because a lot of people generationally will continue to stay in the communities and the neighborhoods that they grew up with, that their families are accustomed to. And so people will just continue to stay in the same areas generation after generation, or if a house is passed down to someone else, then, you know, it just kind of continues down the line. And so then communities are still very largely segregated by past segregation. I mean, like, look around your neighborhood and, you know, like maybe you're lucky and you have a mixed neighborhood, but look, like count the heads and see what the ratio is of people you normally see. Like, is it one, the other, or, you know, more mixed? I mean, here in Bay County, we still have that too, where it depends on where you live, and you can always tell, you know, like what like a neighborhood is largely made up of based on the student population. And so we still have a lot of that segregation that occurs today in unofficial terms because it always has, and most people don't change their dynamic. So that's where we get the de facto segregation. Come on. Okay, so I know you guys have heard a lot about the protests and stuff that happened when we began to integrate. Side note, I apologize if my videos get weirdly glitchy. Like I've noticed on my screen that once in a while there'll be like a line that kind of shoots across the screen. And I hope that's not interfering with what you're hearing or seeing. Maybe you're not even seeing that on your end. We have a new webcam and I think it's something to do with the webcam. My husband said it's something about like the speed of it versus the internet and the computer, and I don't know, he's the techie. So hopefully that's like not negatively interfering too much with you guys. So of course we had a lot of protests of people who were not so good with change. So 10 years after Brown, fewer than 1% of Black school-age children in the Deep South were actually attending schools with whites, making it obvious that the goal of equal protection required not just court decisions, but also positive or affirmative action by Congress and government agencies. And given massive Southern resistance and only lukewarm Northern support, progress also required intense, well-organized support. So this image says massive resistance among white Southerners attempted to block the desegregation efforts of the national government. For example, at Little Rock Central High School in 1957, an angry mob of white students prevented Black students from entering the school, as pictured here. So there were obviously demonstrations that picked up after Brown v. Board of Education. Only 1 year later, African Americans in Montgomery challenged the city's segregated bus system with a year-long boycott that began with the arrest of Rosa Parks, who refused to give up her seat to a white man. Parks eventually became a civil rights icon, as did one of the ministers leading the boycott, Martin Luther King. A year of private carpools and walking ended with Montgomery's bus system desegregation, but only after the Supreme Court ruled the system unconstitutional. And there are several more examples of that. And that section ends with the fact that unfortunately, we are still dealing with a lot of that to this day. So in recent years, we've seen the Black Lives Matter movement really focus a lot of police misconduct that has still been occurring. It took off in Ferguson. We've heard about that in 2014. And then of course in 2020 with George Floyd. And so, of course, we've all been living through that recently. So we're pretty familiar with that case, those cases in general. So the fight for equality and not being racially discriminated against based on the color of your skin is still a fight. It's still something that minorities are having to push back against. There are a lot of statistics and studies and research showing proof that that not all police officers, but a lot of police officers still discriminate and are harsher in their dealings with Black people versus white people. There are studies that show that African Americans are not listened to with the same urgency that white people are when it comes to medical health. Black people are not given the same level of, like, say, medication for a surgery because there's this very old, very inaccurate wives' tale that Black people can tolerate pain more than white people. And it is still something widely regarded as fact in the medical community. And so you have these terrible horror stories of, like, say, Black women dealing with pain at, say, after having a child. I think it was Serena Williams or Venus Williams is one of the twins, almost lost her life after having her child because the doctors did not listen to her about pain that she was having. And she was ignored in a way that white women just simply are not. And so those sort of things are continuing to happen, even in this day and age. Like, I mean, Brown v. Board of Education happened in 1954. We're in 2020. We're talking 70 years. Like, so Plessy v. Ferguson to Brown v. Board of Education, 70 years. Now we're to present day, another 70 years. It takes entirely too long for us to get off our guff and to do the right thing. And it took a lot of these cases here recently for the general public to say, wow, maybe these Black people aren't exaggerating. Maybe they're not lying. Maybe we are treating them like crap. Maybe we aren't doing what we're supposed to be doing to treat people with equity and equality. And it's unbelievably sad that they're still having to fight for basic civil rights that are already afforded to them in the Constitution. There are still people who treat them as second-class citizens or worse. So hopefully we get somewhere and we get a little more enlightened, because it's heartbreaking the level of ignorance that we all still see on a regular basis among people who look at people who are different than themselves as less than. I saw this interview with someone who is Hispanic, and they said that the studies show that if a Hispanic woman goes missing, people do not search for them with the same fervor that they do if a white woman goes missing. And that's true of any minority. And that is heartbreaking, because everybody is somebody's child. Everyone is someone's partner or mother or sister or, whatever. And it's imperative that we treat all lives as equally important to others. And the fact that we don't, that our system still does this sort of by fact segregation and by fact racial discrimination, it's disgusting. I mean, there's really no other way to put it. So let's see. So on page 128, you'll see table 5.1, which is cause of and effect in the civil rights movement. So I know a lot of people, like, the chapter might be a lot of reading and it's hard to kind of get it all down. So I really love the little tables that our book pulls out, because it takes and breaks all that down into sort of like bite-sized chunks. So like when you're reviewing materials and stuff like these are helpful to go back, pull up the PowerPoint that I have saved. If you need, like printouts, if you build yourself a binder, like you can print these out, add it right to it. And they're great little one-page study pieces to help break down the information in a way that is easier for you to retain. So Brown v. Board of Education, political action that followed it was Montgomery and the bus boycott, because people were still discriminating and continuing segregation, even though they weren't supposed to. 1956, federal courts ordered school integration. Governor Wallace in Alabama protested, but nothing else happened. So that would be sort of a political action, but like nothing major occurred. Like the schools got integrated with people grumbling about it. 1957, Civil Rights Act happened by President Eisenhower to enforce integration of schools. In 1957, there was an organization called the Southern Christian Leadership Conference that was formed with Martin Luther King as the president to reinforce this enforcement of integration, to make sure that it was being done like it should. 1960, Civil Rights Act was created, mostly for voting rights. And then a student nonviolent coordinating committee formed to keep pushing because there was a lot of pushback on voting rights. There were all kinds of ridiculous things implemented to try and make it harder for people to vote. And so that's why you saw protests and things happening as a result of that. Interstate Commerce Commission desegregated all buses, trains, and terminals. President Kennedy favored executive action over actual legislation because he was like, sometimes executive action that presidents take are because they know that the votes are not there in Congress and it's something that still needs to happen. So then they sign an executive order making it so because they know they can't get anywhere on the legislative side. 1963, JFK focuses on stronger civil rights laws, not just executive action. He realizes, okay, this isn't enough. Like, we need it to be codified. We need it to be definitive. Unfortunately, before he could implement a lot of the things that he had come around to, he was assassinated. And we'll talk about that more in the presidential chapter. President Johnson picks up that torch and really is the one who gets a lot of the things done. Then we had nonviolent demonstrations in Birmingham. King was arrested. You had the March on Washington with his famous I Have a Dream speech. 1964, we have the Civil Rights Act that covers voting, employment, public accommodations, and education, striking out racial discrimination and segregation with that. 1965, we have the Voting Rights Act. You guys will see information about the Voting Rights Act on the test for chapter 4 and 5. So make sure you're familiar with the Voting Rights Act, what it did, who it protected, what it was before versus after. The political action was that King announced the drive to register 3 million Black people in the South. Like, that was the goal as a result of the fact that they had the right to vote, that now it's time to get them on the voter rolls. 1966, we start seeing focus on the poor. So in the late 1960s, you start seeing people do community action programs to help people pull themselves out of poverty. Some people fight towards litigation, some towards the war protests as far as Vietnam. And then we start seeing some more militant Black power movements, like with the Black Panthers. So when we talk about war on poverty, because we have literally pushed down all of Black society in the United States since the dawn of our country by making them property and then barely taking them out of that to second-class citizenship, and discriminating on where they're allowed to live, what they're allowed to buy, what jobs they're allowed to have, all of these things. At one time, there were, one of the Jim Crow laws was like you had to have a certain level of education, you had to own land, or you had to, be able to read the ballot. But all of those things had not been allowed of Black people. They couldn't own property. They weren't allowed to go to school. They weren't allowed to learn to read a lot of times. And they knew that. So that's why they implemented those Jim Crow laws as a workaround to keep them from being able to vote. And so that's why all of these things happen to push back on that and to try and get them on a more equal footing. And so by doing all those things, by not allowing them to work and own land and to be of an equal status in society, the Black community was much poorer than other people in the United States. So then it became like all these subversive things to try and keep them down in other ways, to keep them from being able to level the playing field. Oh, wait. Okay. So the Civil Rights Act of 1964 definitely strengthened voting rights provisions and attacked discrimination and segregation. So public accommodations, again, were no longer segregated. Title VI strengthened the power of the executive branch to discipline any segregated schools, to basically fine them, shut them down, whatever, to make sure that they hurt for not integrating, whether it be not giving them funding or whatever needed to be done. And it also outlawed employment discrimination by private and public employers, including government agencies, on color, religion, sex, race, or national origin. So federal law also strengthened voting rights by passing in 1965 the Voting Rights Act. So in 1964, we have the Civil Rights Act. In 1965, we have the Voting Rights Act. So literacy tests were canceled as a result of this. Made it a crime to interfere with efforts to vote, because Black people were intimidated when they would go to vote at the polls. They would be threatened. There were all kinds of things that were tried to be pushed on them to intimidate them from voting. Voting rights was strengthened even more down the road as far as our amendments with the 24th Amendment, which abolished the poll tax. Now, poll tax is mentioned on page like 129, 130. See if I can find where it really discusses that. I'm trying to give you a place to check that. Okay. Let's see, 24th Amendment abolished the poll tax in 1964, and in 1975 with legislation permanently outlawing literacy tests in all 50 states, mandating bilingual ballots or oral assistance for Spanish, Chinese, Japanese, and Korean speakers, and for Native Americans and Alaska Natives. So we started seeing larger participation of other groups. In 1965, states of the old Confederacy covered by the Voting Rights Act, 29% of eligible Black residents were registered to vote, compared with 73% of white votes. By 1972, that gap was only 11.2 points. So it definitely was effective. So there's some controversy over the whole poll tax thing. Okay, so used to, like, they had these things implemented of, oh, you've got to pay like a poll tax to be able to vote, knowing fully well that a lot of minorities, a lot of the poor did not have extra money to pay for things like that. So as you guys are all aware, a lot of people, a lot of states require some sort of government ID to be able to vote, whether it be a driver's license, state issued ID, military ID, something, right? A lot of people feel that that is a form of a poll tax because, believe it or not, there are some people who are so paycheck to paycheck and are so tight on funds that they cannot afford the $25 or $35 for a driver's license. And if they live in an area that has a lot of public transportation, they don't need a driver's license. And then it's still like, what, $20 or $25 to get a state issued ID. And a lot of people just simply do not have that extra money in their budget. And by requiring that in some states, a lot of people believe that that is a deterrent and possibly deemed as a poll tax. So it limits people who are poor and minorities, because minorities are more likely to be poor because of all of the ways that we have held them down generationally. So they are not on the same equal footing financially. So there's a lot of controversy about requiring voter ID laws. Now, like here in Florida, you can register to vote with either a driver's license or social security number. Believe it or not, some people of a certain age don't necessarily have a social security number because it was before they like automatically issued them. But most people have a social security number now. And so they can register with either and get verified that they're a real person. The preference is a a state issued ID, because it's quicker, I think, in the database to verify than the social security number. But it's not like a if you don't have this, you can't register. So now if you go to the polls and vote, they want you to have an ID to show that you're you, to match up with your registration. So the workaround to that is if you're registered to vote in Florida, you don't have an ID, you can request a vote by mail ballot and they can send that to you, and you don't have to put a stamp on it to send it back. And you can fill it out and mail it in, and it counts just as if you were to go and early vote or vote on election day. But a lot of people have distrust of vote by mail ballots because of false information and outright lies that have been spread about the fact that it's not a secure system. And it is a very, very secure system. Speaking from experience, having worked with it for decades now, like, it is a very secure system. So that is the workaround to not having ID, but a lot of people are not comfortable with that. They want to be able to go and vote at the polls, but if they don't have an ID, then what happens is they have to vote by what's known as a provisional ballot. So they fill out like a little paper thing, they do their ballot, they put it in an envelope, and it goes back to the office. What happens is you sign on that envelope. When it gets back to the elections office, they verify that the signature matches, because they couldn't do that they don't have time to do that at the poll. And then as long as they can tell it's that person, then the ballot gets run through and it is part of the regular totals. A lot of people assume that it doesn't matter, that they don't like get credit for voting if it's provincial ballot, but they do. And not just got credit, but their vote actually went towards the tally. But that's literally the exact same process as a vote by mail ballot, because you're filling out a ballot, you're sticking an envelope, and you're sending it back to the office. So if you don't have an ID, you're just better off doing a vote by mail, so you're not wasting your time or anybody else's by going down to the polls. So not all states are that open about allowing vote by mail ballots for just everybody. It depends on the state. So for some people, that provides to be an extra barrier for them if they have to go and vote and they can't afford an ID. So, and not every state requires that, but a lot of them do. The Voting Rights Act did help, however, what they call enfranchise millions of people by bringing them into the fold and allowing them to be able to vote. And that was huge. This is one of the largest pieces of legislation that we have ever had, that has ever passed, that, and it does so much, and it changed the game. So this is another really great little table. Table 5.2, registration by race and state in southern states covered by the Voting Rights Act. So here's a breakdown of before and after. So Alabama, before the act, we had 69.2 white registered voters, 19.3 Black, gap of almost 50%. Then after the act, and this is between 1971 and 1972, 80% of white, 57% Black, only a difference of almost 24%. That's huge. Like, cut it in half of the gap. I mean, that's a big difference. Georgia, 35% gap, down to a less than 3% gap, like, et cetera, et cetera, et cetera. I won't read all of these, but that shows you the Voting Rights Act worked, right? Like, it did what it was supposed to do, and it got people registered to vote. And so that is just huge. It's a major accomplishment. So that's on page 130, if you're following along or you want to know particularly where that table is. So one of the next things that Congress really focused on after the Voting Rights Act was the fact that there had been all of that originally de jure segregation for housing and then de facto segregation for housing. So in 1968, Congress passed what's known as the Fair Housing Act, which specifically prohibits housing discrimination. It covered the sale or rental of nearly all the nation's housing. Housing was among the most controversial discrimination issues because of entrenched patterns of residential segregation across the country. Besides the lingering effects of restrictive covenants, local authorities had deliberately segregated public housing, and federal guidelines had allowed discrimination in federal housing administration mortgage lending, effectively preventing Blacks from joining the movement to the suburbs in the 50s and 60s. The procedures for proving discrimination remained quite challenging until Congress passed the Fair Housing Amendment Act in 1988. And so that strengthened the enforcement procedures to make sure that people weren't finding workarounds for discrimination. This law put more teeth in the enforcement mechanisms and allowed the Department of Housing and Urban Development, also known as HUD, to initiate legal actions in cases of discrimination. So that has made a massive difference as well, to where people were able to, move out of, sometimes slum housing, areas of town that were maybe not as desirable to live. It really paved the way for Black families to be able to choose their own way when it came to where they wanted to reside. So the next thing, like I kind of mentioned before, was Black and white mixed, not just Black and white, but all mixed marriages. So this picture is from a Supreme Court case in 1967 called Loving v. Virginia. So the Supreme Court ruled that state laws banning interracial marriage were unconstitutional. The case was invoked numerous times in the court's decisions almost 50 years later that declared marriage a fundamental right for same-sex couples. So this is a basis utilized for not just interracial marriage, but for same-sex couples as well. Because again, discriminating against people just because you don't agree with their personal choice is ridiculous. So 16 states continued to outlaw in 1967 interracial marriage. So in that year, the Supreme Court said those laws were unconstitutional. A Virginia couple, a white man and a Black woman, were married in Washington, D.C., where such unions were legal. When they moved back to Virginia, they were charged with violating the state's laws against interracial marriage. The Lovings challenged the Virginia law. In striking down such laws, Congress declared marriage one of the most basic civil rights of man, fundamental to our very existence and survival. So, be interesting to see if the rest of the Supreme Court hitches to Clarence Thomas's wagon on revisiting gay marriage, because if, for all we know, it could be a slippery slope, and they could very well say, well, you know what, we're gonna take back interracial marriage too. Now I know he's going to be against that because he is in an interracial marriage, but what's to stop them from continuing this slippery slope and undoing everything that was done with the civil rights? They're just kind of picking and choosing random low-hanging fruit to them. But what's to stop them from going after other things? So it's just absurd, the level that they are actually going against the American people too. When polled, the majority of people believe in the right to choose for a woman. Like when the majority of the public is polled, they do not think Roe v. Wade should be overturned. They don't believe that it should be something that is the government's business to tell a woman what to do, because I hate to tell you, abortions will not stop. What will stop are safe abortions. Women used to throw themselves down the stairs. They used to put a coat hanger up themselves. Men who didn't want a baby would beat the woman until they lost the baby. There are so many things that happen that put the woman's life at risk for an unwanted pregnancy, that allowing abortion has stopped. Regardless of your personal viewpoints on, is it a life at conception or not, or whatever, it's simply a matter of science says until the fetus is viable outside of the womb, it's not a life. if it can't live on its own. So what do? Like you protect the right of a life that's not a life over the existing life that is here presently. And we are a secular nation and we base all of our stuff on facts and science. And then this is a personal, I don't like it, it's not for me, I don't think people should do it. Then don't go get an abortion, right? Like that's like, oh, I don't like gay marriage, so don't go marry somebody of the same sex. Like, problem solved, you know? So it's I have not been able to get over this ruling happening at the end of last week. It's insane. And there was also another ruling that occurred that kind of got buried in the news cycle because that happened the day before they overturned Roe v. Wade. And this is where they loosened up. I'm going to get out of the PowerPoint for a second. They loosened up the Miranda rights, Miranda rights ruling 2022. Here we go. Let me share this. Go back to share screen. Okay. Come on. Okay, U.S. Supreme Court's Miranda decision further guts 150-year-old civil rights law. So you'll see here on Reuters, let me see, can you share? So U.S. Supreme Court decision on Thursday illustrated the extent to which the court has transformed a Reconstruction era law meant to protect the rights of freed slaves and marginalized Americans into a formidable shield for the most powerful, including police, prosecutors, and businesses. The June 23rd decision bars lawsuits against police for using evidence obtained without advising people of their rights. The Miranda warnings the court mandated nearly 60 years ago that have since become the framework through which most Americans understand their rights against police intrusion. Remember, we talked about that when we talked about the civil liberties chapter, right? Like we went into detail about the Miranda rights. So this is taking that and backtracking it. Like the whole point of the Miranda ruling was to protect the people. And this is taking another step away from our civil liberties and civil rights. The 6-3 ruling in Vega v. Teco, I'm probably butchering both of those names, which was expectedly split along partisan lines because we had a 6-person conservative, 3-person liberal court, nullified essentially the only direct remedy available in those situations. Police officers are notorious for evading internal discipline and legal consequence, even for conduct that constitutes a crime, like assaulting someone to compel a false confession. Justice Elena Kagan noted in the dissent that the court ruling still allows a victim in a similar situation to suppress the improperly obtained evidence at trial. But sometimes such a statement will not be suppressed, Kagan wrote, and sometimes as a result, a defendant will be wrongly prosecuted, convicted, and spend years in prison without any redress. In fact, that was nearly exactly what happened in the case before the court. Terrence Teco, a nurse assistant, alleged that the LA Sheriff's Deputy Carlos Vega didn't Mirandize him and strong-armed him into confessing to sexual assault, including threatening his family for deportation. The state tried to convict him twice, but he has never been found guilty. One of his lawyers said that jurors urged him to sue after trial because many believed he'd suffered an injustice. He was found not guilty despite a supposed witness ID and a supposed confession. And I'm not going to go through and read the rest of this. I will post it though for you guys to be able to take a look at. So it isn't just the it's not just Roe v. Wade. It sounds like a conspiracy theory, and I don't mean it to be, but a lot of people believe that they're coming for a lot of our civil rights. And that has not been a story that you've heard about repeatedly. We've all heard about Roe v. Wade. As somebody who literally does this for a living, I didn't even hear about the Miranda case. I heard it from a friend. So this happened on Thursday. I found out about it on Sunday when I was at lunch with a friend and we were talking about the Roe v. Wade situation. And then she was talking about the Miranda thing. And I was like, I'm sorry, whoa, back up. What? Like, I had not heard word one about it. So they definitely buried it. They did it right before, because they knew they were going to do Roe v. Wade. So they ruled on this other thing and it didn't get that much traction, but you put those two things together, Thursday and Friday, and well, I mean, what are people supposed to think? Like that we're taking steps backward on our civil liberties, right to privacy and right against police intrusion. Those are both right to privacy matters. Those are both situations of government and police overreach. And the Supreme Court is saying it's cool that like they have more rights than we as individuals. So that's a problem. So that's another example for you guys of something that is being changed. So it's just important to keep an eye out for those sort of things. And remember that the Supreme Court is made up of who appoints them, right? Like, and they're people just like everybody else. So they've got their own opinions, they've got their own interpretations of the law. And just like with our government officials, our system is what we make it. And so we put some people in office who ended up choosing to put the current people on the Supreme Court. And those people have now turned back the clock on our civil liberties and civil rights on two separate matters. And Clarence Thomas wants to go further with it. So it'll be interesting to see what sort of legal pushback there is, and just how things progress. So another matter that a lot of people don't think about for civil rights is mass incarceration. So again, our system is not perfect because it's made up of people. People are not perfect. So mistakes happen as a result of people being imperfect and people bringing their own thoughts, their own ideas, their own beliefs to the jury with them, to the courthouse, to the judges' robes, to the attorneys who are prosecuting and defending. All of these people bring with them their life experiences and their personal beliefs all day, every day. A jury can't check that at the door either, right? Like, we are all products of our environments, of our upbringings, of our experiences that form who we are and how we look at them. And so based on that, there are times when decisions are made in a very unequal manner because of that. So, so this is the end. This is on page 132. So some have argued that mass incarceration is a key civil rights issue because there's a large disenfranchisement of convicts once they're released, once they have finished their whatever, again, their probation, their community service, their fines, whatever it is that they are sentenced to once they have finished it. A lot of people are not given their rights back, even though they have done, people say don't do the crime if you can't do the time. But once they've done the time, at what point do we say, okay, we're done punishing you? And unfortunately, our system continues to punish people for decisions or sometimes false accusations and false convictions because, again, the system's not perfect. There have been a number of people over the years who have been falsely imprisoned, and those people get screwed by an imperfect system. And then if they're not given their rights back, they are literally punished till the day they die for something that they may not have even done, or even if they did, they've already done their time for. So more than 2.2 million Americans are presently incarcerated, most in state prisons and local jails. You probably know a couple of them, right? Like you throw a rock and hit somebody with a record. African Americans account for 1/3 of those incarcerations, 1/3, though they make up only about 12% of the US population. Now, I have had people argue that, well, they clearly commit more crime. Do they though? Do they? Or are they in the wrong place at the wrong time? Do they match the description of someone and then are falsely imprisoned because they happen to be a Black guy in the wrong block at the wrong time and the other person went the other way, right? Like that kind of thing happens all the time. So a lot of states restrict voting rights of former felons, and they don't usually let them get them back like after their rights have been restored or should have been restored. Sometimes they don't allow them to be restored. And that has a large disproportional effect on the African American community because you see these numbers, 1/3 of the 2.2 million Americans incarcerated are African Americans. So even though they're only 12% of the population, that's a large group of the African American community who a lot of times don't get their rights back, therefore can't vote. So then that community is not being represented properly at the voting polls, right? Does that make sense? So, and that's a problem because now the African American community is not getting proper representation because they're not allowed to vote, right? And a lot of people actually argue that voting rights should not be taken away of felons because the decisions of government and our elected officials and our judges are still impacting those felons on a daily basis, right? Like they still have to pay taxes, even if they're on probation. They still have to go to work. They still have to do all of these things. So what the government does still impacts them. So a lot of people argue that they should actually still be able to have a say in the process because it still impacts them on a daily basis. And that it's maybe not like an effective means of punishment when they're already doing jail time or probation time. And by the way, probation is not free. Like you got to pay for that every month. And if you've got an ankle monitor, you got to pay for the ankle monitor on top of that. Plus you have fines on top of fines. You've got attorney fees, you've got fines to the court, fines to probation, you've got community service hours you have to do, you've got restitution upon restitution upon restitution. So a lot of people say that taking away voting just adds like insult to injury. So so there is kind of an argument that that doesn't make sense, especially when you look at how disproportionate our legal system punishes Black people versus white people. So so that's another issue that we have, okay? So now we're in the section about explain how the courts have evaluated recent civil rights concerns. Sorry, give me just a second. I'm just curious to see where we are. Okay. Let me just say, okay, we're doing good. So civil rights have been extended to other groups, right? So we've talked about African Americans, we've talked about women. One of the things that women still fight against, so we've talked about minority discrimination of Black people, of Hispanics, of Native Americans. One of the things that we haven't discussed too much is discrimination against women. Although Roe v. Wade is a great example of that because there's no discussion, to get graphic for a second, there's no discussion on men taking personal accountability for their reproductive health. It's always geared towards the woman. The woman is punished because she's the one who is stuck biologically carrying the child. But what about the men who bring the sperm to the party? Okay, where's the requirement? Okay, if I have to have this child, who's going to help me raise them? Are you going to force child support on my rapist or on the deadbeat guy who I didn't know was a deadbeat until he heard the words, I'm pregnant? Like, are you going to hunt him down and make sure that he's doing his part to take care of this child? Are you going to make him get, say, a vasectomy so he can't be a deadbeat dad to somebody else? We don't talk about any of that, right? Like we only talk about women should keep their legs closed, women should have more self-control, women should just do whatever women have to do. But there's an old saying where women used to be told, well, if you keep your legs closed, like to the point where you got like an aspirin between your knees, you won't get pregnant, which is ridiculous and obviously not true, especially if you're forced, right? Like if you're assaulted. But nobody ever talks about how men can prevent unwanted pregnancy. Two-way street, wrap it, get a vasectomy if you don't want any kids, right? Like there's all kinds of ways that the other sex can also help lessen unwanted pregnancy. But people aren't ready to hear that. So that is an issue. But Roe v. Wade is a perfect example of discriminating against women for having unwanted pregnancy, but not others. So Title VII of the Civil Rights Act really helped move things along for the modern women's movement. So in the 1970s, the court established gender discrimination as a highly visible civil rights issue because women had still largely been discriminated against, still are largely discriminated against. Court decisions designed to deal with discrimination against women have been used to protect people from discrimination based on sexual orientation and gender identity, which the Supreme Court seems to be wanting to try and push back on, including action that was taken under President Obama's administration. So there are several different things that women have been discriminated on. Education, being able to run for office, even being charged more for health insurance. Until we had the Affordable Care Act, women were charged more for health insurance because we could get pregnant and that costs money, right? Like OBGYN and the actual having of the child, yada, yada, yada. And because women go to the doctor more. But when research was actually done, women cost the system less money than men do for a couple of reasons. One, not every woman has kids, okay? Like, let's not just punish everybody for having a uterus. That's insane. Two, women go to the doctor sooner because they don't want to get sick, because a lot of women are raising families. They are keeping a household going. They are like the person who is the glue of their family. Like, I ain't got time to be sick. So I need to go to the doctor and get this like little thing handled before it becomes a big thing. Men statistically wait until like body parts are falling off, right? like men, generally speaking, and what studies had shown were that they were not going to the doctor like they should for preventative services, right? Like they were reactionary as opposed to, like making sure something didn't get to be a thing, right? So men actually cost the healthcare system more money. And under the Affordable Care Act, women stopped being charged more over just some hypothetical nonsense that was thrown out there, like spaghetti, throwing it to see if it sticks on the wall, because of basic sexism. So that has been a thing, of course. So on page 133, you'll see this little addition here on have women achieved equal rights. So the Supreme Court has consistently upheld the principle that women should have the same rights as men. Since 1960, the US has made great strides towards gender equality in some areas, but as the data shows here, not all. So women used to not be able to go and do further education like college unless they came from a wealthy family. They had to go to like an all women's school, like Florida State, for example, used to be an all women's school. That's how it started out. And so a lot of females were not among the most educated because they weren't allowed to go, or they didn't have the financial means to go. We didn't always have Pell Grants and financial aid and Bright Futures and student loans, right? So as you see here in 1960, only 39% of women were college students. And then when and still all the way up to 2000, we still were not at that 50-50 range. Then in 2010, now 56% of women, so over half of the population, and then 57% in 2019. So we have largely made up that gap, but it was a long time coming. Now, politics. This is interesting, and a lot of people do not realize this, but okay, so in theory, we've talked about the makeup of Congress, right? So the House of Representatives is based on population in a state, right? How many House of Representative members you have is dependent on your population. The US Senate is the same for every state. Everybody gets 2 US senators, but your House of Representatives varies because they are both broken up in different ways to represent our population. So if it's a true representation, we should have half women and half men in Congress. We should have, what was that number about African Americans? 19% African American, whatever percent Native American, et cetera, et cetera, et cetera. We should see a more true, diverse Congress. That is not what we have, though. So in 1960, only 4% of women were in Congress. 4%, half the population. It's pretty much always been half the population of women, right? Only 4%. And then it dropped to only 2% in 1970. I'm not sure what happened there. In 1980, still at 2%. 1996, 2013, 2010, 17, 2019, 25%. So we're still not up to half. And then we talk about state legislators. So that's not at the federal level. Obviously, like we're talking about like your state house and your state senate, which we do have. So none in 60 and 70, 1980, 11%. 1990, 17, 2000, 23%, 2010, 25, 2019, 29%. So a couple of reasons for this disparity. One, we used to not be allowed to run for office. Two, we used to not allowed to be able to vote for people, right? So that puts us generationally behind because, you know, it was white male, white male, white male, white male, white male. So that's part of the reason why we haven't had as many people, and we'll talk about this more during political campaigns chapter, but there's something known as the incumbency factor. So if you are holding the seat and you're running for re-election, you are the incumbent. So you have more name recognition, you have more experience fundraising at that level for that position. So you're going to have more people readily available to give you a check, send you money, whatever, right? Volunteer, all of that. So you're automatically ahead of the game and you have an increased likelihood of being elected over a newcomer. Now, those numbers shift a little bit if it's two people who like neither of them have held the office before, like somebody's term, like they're term limited, or somebody dies or gets kicked out or whatever, right? So those are a couple of things. Also, if you have ever paid attention to questions being asked of political candidates, you will notice that it's very different, the types of questions that are asked of women versus men. When Hillary Clinton ran for office, she's run for several different positions, but the last 2 times she ran for president, they focused on things like her wardrobe. I didn't hear anybody talking about the suit that Obama wore, right? But you certainly heard people talk about the fact that she wore pantsuits over dresses and skirts. Like, be happy she got clothes on. Like, what do you, like she'd show up in tank top and shorts, right? Like, she's appropriately dressed for a professional event. But we focus on things like their appearance. Like, do women look well put together? Like, how attractive are they? Like, we don't do that with men. We focus on the issues more with them. Women are asked in interviews when they're running for office, how are you going to balance your time? You're married, you have children. How are you going to be able to still do, you know, your wifely duties and your duties as a mother and be able to do this job? But men who are married and have children are never asked, how are you going to balance your family life and your work life? Because it's assumed that women are the primary caregivers. So it's not like on equal footing in that respect. And then on the flip side of it, and specifically like here in the South, okay, if you're not married, you don't have kids, what's wrong with you? Do you hate children? Are you so unpleasant that you can't find a man? Do you not like men? Or do you swing the other way? And then that's like a whole other type of judgment. All of those things, we put the burden on women in a way that we don't put on men. And that has been shown over and over and over and over again. And all those things hinder a woman being able to run for office. So one of the things that I always think about when I think about gender discrimination, some of you may be familiar with who Lauren Conrad is. She was like on The Hills, is like a reality show. Anyways, she has since like started her own clothing line and some other things. I don't know much about her in the sense of like what all of her avenues of income are, but she is CEO of her own industry, of her own company. And she was on a radio show one time and she's being asked questions. And this smart aleck guy thought it would be cute to ask her what her favorite position was, as in sexually, because yeah, that's an appropriate question. Which I'm always shocked at how many men have asked myself and other women I know that question. It's vulgar, really. But she quipped back incredibly fast with CEO. And I find that to be a phenomenal answer. You can probably even find it on Etsy. I'm sure there's bumper stickers and t-shirts, because if there's anything creative out there, Etsy's going to have it, right? So, but that shows you the difference. Like, you wouldn't have a high-powered male leader in a field come onto a radio show and nobody would ever think it was appropriate to ask him what his favorite sexual position was. But they immediately demeaned her and sexualized her and just focused on the fact that she was a woman and attractive, and therefore let's treat her like a second-class citizen. And that same attitude permeates when women run for office. And so that causes a lot of issues with equality. And so therefore we are not equally represented in the political world, because we are put, those sort of antiquated viewpoints of women are put on us, and society has trouble breaking away from that and realizing that that's a load of horse crap, right? Like, that there's no reason that women can't do whatever a man can do, right? And vice versa. Like, men can do what women can do, minus actually having children. Like, but they can be a stay-at-home dad, they can raise the kids, they can clean the house, they can push a vacuum cleaner. Like, why is it just one-sided? Like, it should be like equal across the board, right? Like, they're supposed to be partners. So so that is one of the ways that women still push for equality and an end to blatant gender discrimination. So another problem that we have is income earnings. So depending on the field you're in, it might be closer to equal, but men always make more money than women in a job. So white women earn 80% as much as their male counterparts, compared to 91.8% for Black women, 78.3% for Asian women, and 86.7% for Latino women. So you can see the breakdowns here. The old book actually had like a breakdown of like different types of fields. Let me see if it's on the next page. It is not. So they would show like, teachers versus whatever to show a disparity. But this is still important to be able to get a visual on. And it's the same sort of things that we put onto women when they're running for office that we put on for income earnings. Oh, like, if your kid's sick, you're going to be out more. What if you get pregnant? What if there's a family emergency, like, and you have to go and get the child? Like, what if there's a crisis at home, like you're the one who has to deal with it. So it's assumed that women are not going to be able to work at the same level as men. And then men get discriminated too, where like if they have to be the one to go home with the kid, I've actually heard situations where people have been asked by their bosses, well, why can't your wife go? Like, we can't get a leg up if we're not all treated like the same across the board, right? So, and it's not just about equality. So there's a very large difference in equity and equality. So we have fought for equality in a lot of ways, and though that's important, right? Like the same earnings, that's equality. But equity is making sure that everybody has the same tools to be able to succeed. So let me show you an example of what I'm talking about here. All right. Equity versus, there we go. Thank you, Google. So let's see. Let me share the screen with you. Equity versus equality. So equality means each individual or group of people is given the same resources or opportunities. Equity recognizes that each person has different circumstances and allocates the exact resources and opportunity needed to reach an equal outcome. So, okay, fine, you're a woman, you're pregnant. That doesn't mean that you can't do your job until you're like out on leave. Like, what if a male has to have surgery? Like they would be given that equal footing and not being given grief. So it's all about, yes, we're all equal, okay? And so we all need the same resources and opportunity. Equity is a step further on making sure that each person has what they need to be able to succeed. So like if you've got, that's like the Student Resources Center, like helps with equity. Okay, this person with ADHD needs additional testing time. We're going to make sure they have that, so they have what they need for an equal outcome to those students who don't have that barrier. So that's equity. Does that make sense? So they're both important. So equality provides the same resources to all and pays little attention to the fairness of desired outcomes, but the practice of equity requires more foresight and intentional allocation of resources tailored to individual needs to reach desired outcomes. So, we've heard a lot of people for a long time talk about equality and how equality is important. And obviously it is, right? It is important. But equity is something that a lot of people are really focusing on more now than equality, because they're realizing it's not enough to just have the same resources out there, because not everybody needs the exact same resources in the exact same way. So make sure I've got this shared. Okay, I do. Good. So that's where equity comes into play. So let's see, we've already gone over that and that and that. So we are on page 134. We're getting there, guys. So Title IX of the 1972 Education Act prohibits gender discrimination in education. This was expanded in Franklin v. Gwinnett County Public Schools, which is talked about in the middle of page 134. Monetary damages could be awarded for gender discrimination, rather. Complaints to the Education Department Office for Civil Rights about unequal treatment of women's athletic programs nearly tripled in the 2 years following this case. So it's led to a lot of college athletic programs to try and make sure that that doesn't occur. Unfortunately, there's still a lot of gender barriers that happen, and especially in a lot of STEM fields, your math, your science, your engineering. I know when I was growing up, I heard all the time. So I wasn't very good at math. and I know I've joked about that in previous lectures. I learned when I was diagnosed with ADHD in graduate school. So they do a million different tests. They ask you a ton of different questions, and they even have you do like math and English and different things. And I actually tested higher on math and science than on other fields where English and history had always been my strong points. And I was like, I'm sorry, did you get my test mixed up with somebody else? And they're like, no, really, like your brain actually does work a little. I mean, they were close, but worked a little bit better in math and science. And they said, had you been diagnosed sooner and had the proper tools that you needed to help cope, because I always told them I had a lot of anxiety over math and science. I had trouble with memorization. And so I couldn't remember like the formulas and stuff. And so I just didn't do as well in it. After like division, I was done. And they said, had I had the right tools, I would have actually done incredibly well in math and science. But I'd always chalked it up to that women were not as good at math and science, because that's what I'd actually been told my entire life. I heard that in the school system. I heard it at home, because it was a misnomer that a lot of people believed, and that gender discrimination still permeates our education system, even though it's not accurate. And so that's why we don't have, until here recently, we haven't had as many women in the math and science field and the engineering field. And, even in NASA, for example, even though like the original formulas to be able to go into space were created and perfected by women. So those are very old school ideas that have been, and honestly, I've never done any research. I don't know where that cockamamie idea came from, but I know it has definitely hindered a lot of women over the years, and it continues to be a problem that our education system has tried to rectify. Okay, so the next thing that your book talks about is sexual harassment. So the Civil Rights Act focused on that as well. So during the 1970s, Title VII of the 64 Civil Rights Act, courts began to find sexual harassment to be a form of sex discrimination. In 1986, the Supreme Court recommended two forms of sexual harassment. One, quid pro quo harassment, and that is simply, if you do a little for me, I'll do a little for you. And I'd hate for you to lose out on that raise because you wouldn't go on a date with me or whatever, right? Like that is quid pro quo. So explicit or strongly implied threat that submission is a condition of continued employment. I'd really hate for you to not take me up on my offer to, go out for drinks and then back to my place with that promotion coming up. We've got reviews, we've got raises, like that's quid pro quo. Hostile work environment is harassment that creates offensive or intimidating employment conditions. So people talking about inappropriate things, people making sexual or lewd comments, that kind of thing. It remains very prevalent and relevant today even. The Office of Civil Rights has advised colleges to adopt stricter harassment procedures. And they started pushing that in 2011 because it is still a very, very large issue. In 2011, more than 7,000 colleges and universities received federal money to adopt strict procedures to deal with sexual harassment and assault. They told colleges to shift the burden of proof from the accuser to the accused, to allow accusers to appeal not guilty findings, which is actually contrary to the Fifth Amendment's ban on double jeopardy, and to refrain from allowing accused persons to cross-examine their accusers, which is contrary to the Sixth Amendment. These procedures have led many campuses to charge false accusations and unfair proceedings. However, 2018, Betsy DeVos rescinded Obama-era guidelines and announced new rules that strengthen protections of those accused on college campuses, which is sort of hit or miss on how people feel about that, because a lot of people, everybody knows of a story of like a false accusation, right? Or a situation where, like somebody was innocent but accused of something because somebody was mad that somebody broke up with somebody or whatever. I mean, we just saw, like the Johnny Depp Amber Heard situation all over the news. Um, and, most people say, like, always believe the accuser, trust the victim. And then there are also occasions where people aren't really victims and they're lying to punish someone for something. So that's where some of that has come into play. But then we also have to really do our due diligence to research and make sure that we are not fighting for justice of true victims of crimes of that nature. So, or of any nature for that matter. So those are things that the Civil Rights Act has tried to protect better. It's still something that the system struggles with, but something that they are trying to make improvements on. So we've talked about African Americans, we've talked about women, we've talked about sexual orientation and the LGBT community to some extent. So your book has a little section, not a lot, but a small section on Latinos and civil rights and their fight for that here in the United States. So Latino and Hispanic encompass a wide array of people, right? With a lot of different origins and cultural identities. Civil rights issues have varied a lot by group and place, like what is needed for one group of Hispanic people or Latino people might be different from another group based on their personal experiences, which is where equity comes into play. Mexican Americans, as we're all aware, have faced a lot of discrimination, legal and unofficial, a lot of pushback, on immigration. And for those of you who haven't heard about it, there was that case where it's like nearly 50 people were found dead in a smuggler van where they were trying to migrate into the United States, and there was no air, they had no food, they had no water, they had no access to fresh air. And it was just a horror show that occurred recently. I want to say it was in Texas. And that's been all over the news this week as well. There were also a few dozen people, or maybe it was just a dozen people or so, who drowned in the river on the other side of the border wall in Texas, trying to migrate in. And immigration is definitely one of the things that's a trigger button issue for a lot of people. A lot of people use that as a means to discriminate people who are here legally, even people who are illegally. They're still people, right? Like, we can all still treat each other with dignity and respect, and enforce laws without being jerks about it, right? So that's definitely something that has caused a lot of issues. In recent years, we've tried to expand immigration restrictions. President Trump tried to build the wall between Mexico and the United States, which was done shoddily and was not finished. And people, like, it's a wall, it doesn't go all the way through space. So people have ladders, right? So it wasn't effective, it didn't work. So there are just a lot of different things that like the Latino community has pushed back on for better equity and better treatment. We now have the group of the League of United Latin American Citizens, kind of like the NAACP, but for Latino and Hispanic citizens. It was founded in 1929, and it uses legal strategies to fight discrimination in different manners. So since the 60s, any rights for Latinos have always been intertwined with immigration, because people assume that, like, if you're not white, you're not black or whatever, you're here illegally, which is just ignorant. So, your book gives some specific examples. One of the things that people talk about is, like the DACA situation where, children who are born here in the United States, like, okay, if you're born in the US, you're a US citizen, but then what do we do with the parents, who aren't US citizens yet? They haven't been able to go all the way through the process or whatever. So, so that causes a lot of problems for people. So, so Trump tried to discontinue that program for, so Obama basically created like a quasi-legal status for about 5 million people who were in the US illegally, but had children who were US citizens. Trump said he was going to end that. Federal courts blocked it and said, no, you're not. And so there's been a lot of back and forth about whether or not that's the right call. So unfortunately, like, immigration is sort of a continuing standstill issue depending on your personal feelings about it, and has been just this back and forth battle for a really long time. And immigration wouldn't even be needed as much if we had like a better, equitable global economy, and if they weren't literally fleeing for their lives, where certain areas of Central and South America and Mexico have become increasingly violent and just not safe. I mean, there are a lot of people who are coming here are literally just trying to not die and to be safe with their children. And so it's a matter of finding like a proper like compromise to maybe not endanger people's lives, but find a way for them to like legally go through the process, maybe once they're here, of becoming a US citizen. Like, there's so many, maybe we should do this, maybe we should do that. And it really depends on who's in office as to the focus on the best way to handle immigration. So this says, immigration is one of today's most controversial issues. Supporters of immigration advocate for the rights of undocumented people and believe that they should have a path to American citizenship. So, of course, it just depends on, on where you stand on it. So the next group that your book talks about is Asian Americans. So that encompasses also a wide group of people with different backgrounds. So I think I talked about this before in like the federalism chapter, maybe the chapter 2. So in the 1850s, we allowed for a lot of Chinese immigration to come into California to help with the railroad, to help with the gold mining that we were doing and all of that expansion out west, with the promise of they'd be able to get some land, they'd be able to become US citizens, they'd be able to bring their families over. Same kind of crap we did to enslaved African Americans, right? Oh yeah, you work so long, you get 40 acres and a mule, you get this, you get that. But in 1870, Congress said that Chinese immigrants were ineligible for citizenship, even though that's what we promised them to get cheap labor. In 1882, Congress created something called the Chinese Exclusion Act, which stopped all Chinese workers from even entering the US. We just always a hot mess. Like, we can't ever do the right thing up front. Like, we always have to go back and fix ourselves. It's ridiculous. So in 1898, there was a court case called US versus Wong Kim Ark, which granted full citizenship to anyone legally born in the US. So in 1898, that is what established, if you're born in the US, you're a US citizen. And so that, made a huge difference for people. So let's see, at the time of the Exclusion Act, most Chinese people in the US were single male laborers with few women and children. The few Chinese children in San Francisco were denied entry to public schools until parents of those who were American-born pressed legal action. And even then, they had to attend a separate Chinese school. American-born Chinese children could not be denied citizenship. However, in 1898, they ruled in the U.S. v. Wong Kim Ark that anyone born in the U.S. was given full citizenship. New Chinese immigrants were still barred until 1943, which is insane. Like almost another 50 years. After China had become a key World War II ally, Congress repealed the Chinese Exclusion Act and permitted Chinese immigration once more. Because they did something for us. We couldn't just do the right thing after they'd already done something for us by building railroads and mining for gold. And then we screwed them over. And then they helped us on a larger level in World War II. And we were like, maybe we were wrong and we should not do that. So it wasn't just the Chinese that we decided to give guff to for the Asian American community. We also did the same with Japanese immigrants. So people who had either long been immigrants and been established in the United States or were born in the United States were sent to internment camps in World War II. You know, internment camps, just like the Nazis did to the Jewish community, but not quite on that level. Like we weren't like sending them to gas chambers and stuff, but we were imprisoning our own citizens because they looked like the people who attacked us at Pearl Harbor. Read my face. Like nonsense. We did the same, not quite the same thing, but we've treated Muslims the exact same way since the attacks on 9/11 because they look like the terrorists. You know what? Ku Klux Klan looks like me. Hopefully nobody punishes me for the actions of those crazy people. Right? It's the same thing. Like it's like mass discrimination for the actions of a few extremists. So 120,000 people were forcibly relocated from their homes. For any of you who are sci-fi nerds, you should be familiar with the name George Takei. He played Sulu on the original Star Trek, and then he was in the movies, and he's done a lot of stuff, and he's a very active and prominent LGBT activist. And I actually recently got to meet him back in February, and he's amazing. But I digress. So his family was actually one of the families that were forcibly relocated and put in internment camps, even though he was a US born citizen. So the camps were not closed until 1944, where then people were able to actually go back home, which is insane. There were 10 internment camps, mostly in Western states, and characterized by overcrowding, insufficient food, and primitive sanitary facilities. The Supreme Court ruled that the internment was constitutional on the grounds of military necessity. So it's okay to screw over our own people as long as they don't look white. That's basically what we've done since the dawn of our society as the United States. 1944, Roosevelt closed the camps and ended internment. Most of the internees would never recover from the property losses and health problems that they suffered. Not until the Civil Liberties Act of 1988 did the federal government formally acknowledge this denial of civil rights as a grave injustice that had been motivated largely by racial prejudice, wartime hysteria, and a failure of political leadership. So yet another example of how we have wronged people out of fear and hysteria. And it's sad on so many levels. During World War II, many Japanese Americans were forced into unsanitary internment camps on the grounds of military necessity. After the Japanese government launched an attack on Pearl Harbor, internees faced great losses both during and in the aftermath of internment. Native Americans, which we have definitely discussed before, obviously they were royally messed over by white immigrants, because that's what they were, right? Illegal immigrants. Like that, all the people that created the colonies were illegal immigrants coming over. So in the early 1800s, the court defined each Indian tribe as its own nation and declared Native Americans to be non-citizens of the United States as a result. In 1823, there's a case of Johnson v. McIntosh, where the Supreme Court declared that Native Americans did not actually own the land upon which they lived, even though they owned it before we ever got here. Wrap your head around that. Doesn't make any sense, does it? In 1830, there was something called the Indian Removal Act, which forced Native Americans to give up their own land east of the Mississippi and remove them to tribal reservations on less desirable land west of the Mississippi. In 1924, Congress granted citizenship to everybody born in the U.S., including Native Americans. Though they were now citizens, it wasn't clear whether the government viewed them as individuals or as members of tribes. Several pieces of legislation enacted in the 19th century, including the 1887 Dawes Act, sought to break up tribes by encouraging individuals to lead their groups and strike out on their own. 1934 Wheeler-Howard Law, however, renewed tribal law and tribal self-government, though individuals were still free to leave their tribal lands. So in the 1960s, Native Americans started protesting, going to court, asserting their tribal rights to improve their situations, and said, you know what? Enough is enough. Like, we were here first. You are trampling all over our way of life for your own personal selfish reasons, and it's not okay. So the federal government ended up responding with the Indian Self-Determination and Education Assistance Act, which gave Native Americans more control over their own land. In 1987, the Supreme Court freed Native Americans from state regulations prohibiting gambling. And they did that as a very watered down, I'm sorry for killing your people and taking your land. But here you can go make some money with casinos, which is insane. So anyways, one of the things that this also changed was when Native Americans were able to go to schools, one, they were forced into our public school systems, or into our school systems rather, and they were forced to learn English and to learn about Christianity, and they were forced to trying to whitewash the natives is what we were trying to do. And so during the Indian Self-Determination and Education Assistance Act, they were able to now learn in their own language. They were not forced any sort of religion. And they were able to have just in general more self-determination. Let's see. They were actually forbidden to speak their own languages until reform started in the 1930s in schools. Forbidden. Can you imagine, like, if all of a sudden somebody came in, let's use a large country who thinks that they can take over whatever they want. How about Russia? Okay. Let's say Russia, like, does Ukraine, they win, they take over all Europe, and then they move their butt west side. Let's say they take us over, and now we are banned from speaking English and forced to learn Russian. First of all, it's a hard language from what I understand. And second of all, that's exactly what we did to Native Americans. We colonized and then tried to force them to be like us. It's disgusting. It's terrible. I can't even fathom somebody doing that, like, to me as an individual. Like, I can't even fathom that level of autonomy being taken away. And it's heartbreaking that, again, we couldn't do the right thing in the beginning. We had to go back and fix it. So, I mean, and they say, you know, when you know better, you do better. And so as we grow and evolve, hopefully we're knowing better and doing better, although the recent Supreme Court decisions seem to be going backwards on that. It's just frustrating that we acted so incredibly selfishly against other human beings for our own self-righteous needs. It just never had to be like that. So another group that your book talks about that have fought for their civil rights, and this is in more recent years, has been Americans with disabilities. So there's been a lot of discrimination against the disabled community over the decades. A lot of derogatory terms, right? Like we've heard the R word used for people with maybe mental differences. That's the one that comes to my head, but I'm sure there are other ones too. People are actually getting away from the term of disabled Americans. Some people say disabled Americans. Some people actually say people with different abilities, or the differently abled as opposed to the disabled, because that implies that there's something wrong with them, as opposed to there's just a difference about them. Doesn't make it wrong, just makes it different. So a lot of people are going away from disabled to differently abled, which I think is phenomenal. I personally am still working on reprogramming my brain from disabled to differently abled. I usually have to correct myself. I usually say disabled, I mean differently abled. But I do think that that's like a step forward in the right direction of how to think about people. Like, just different doesn't mean that you're at a disadvantage, doesn't mean that it's a negative term. It's just different. Different is just different. Doesn't have to be less than or bad. So the first step towards protecting rights for differently abled individuals was the 1973 Rehabilitation Act, which outlawed discrimination against individuals with disabilities. And that was not really paid attention to very well. Your book references that as a little notice provision. So it didn't really help very much. So people of different abilities and loved ones of people with different abilities got more organized and pushed harder. And in 1990, the Americans with Disabilities Act was created. So that creates equal employment rights and access to public businesses. So that's why you see wheelchair ramps and handicapped, which a lot of people are getting away from the word handicap stalls. I don't know if people will get to a point of saying differently abled stalls, but basically stalls that can allow for a walker or for a wheelchair or for something along those lines. And it prohibits discrimination in housing, employment, and healthcare. Downside is it's very difficult to prove when you've been discriminated against for, say, like employment, unless somebody specifically says to you, we don't want somebody in a wheelchair, right? Or we don't want somebody your age. It's very difficult to prove that because, a lot of states are right to work states like Florida, and they don't really need a reason. So it can be difficult to push back on that at times, but at least there are better protections. So your book says the impact of the law has been far-reaching, and business and public facilities have installed ramps, elevators, and other devices to meet the requirements of the ADA law of 1990. Oh, sorry. So that has been a huge push forward for people who, without it, just simply can't access places. I have an aunt who was born with a lot of health issues, and she has been bound to a wheelchair for the majority of her life. Her legs were amputated, and without housing accommodations and apartments that are built for people who are wheelchair bound, and businesses having their doors created where it's wide enough for a wheelchair to go through, there'd be so many things that she would be barred from because of a situation that is beyond her control, something she was born with. So it's life-changing for people to have those protections. So the next group, which we've talked about a little bit already, is the LGBT community. Recently, a lot of people have been referencing it as the LGBTQIA community, which sounds like a mouthful. It stands for lesbian, gay, bisexual, transgender, Q. I'm so sorry. I forget what the I officially is. Let me look it up because I don't want to be incorrect. The A is for asexual. LGBTQIA. The I is for intersex. What does intersex mean? So honestly, until I heard this referenced on NPR recently, I had not heard of the term, or I had not heard much of, oh gracious, I'm so sorry. I just messed up. New share the right thing. Okay. I had heard the term intersex before, but I glossed over it. You know, when you don't know what a word is, you just kind of like keep it moving. I have to, sad to say, I did that. I didn't know what it was. You know, I know what pansexual is. I know what asexual is. I knew what all the other things were. And I did not realize that I was ignorant to this. So when I heard it recently, I actually did look it up. So intersex are individuals who are born with several sex characteristics, including chromosome patterns, genitals, who, according to the Office of United Nations for Human Rights, do not fit typical binary notions of female or male bodies. There are people sometimes who have like both sometimes. So like this says, for example, a person might be born appearing to be female on the outside, but have mostly male typical anatomy on the inside, or vice versa. So so that would be someone who is considered to be of intersex. So, and I feel terrible for not knowing that before, but I'm glad I know it now. Again, you know better, you do better. So so a lot of people are using that shortening now as opposed to just LGBTQ. They use LGBTQIA Americans. It's definitely one of the largest current civil rights movements in our country. That's of no surprise to people. In 1969 was when it really started to kind of be like present. You know, we had, you know, after the civil rights movement and like around the time of like Vietnam, like all of that, like people started to be more open with their sexuality. There was a riot that occurred in the Village in New York City after police ended up raiding somewhere where there were a lot of people in the homosexual community. And so there began to be a lot of pushback from that community about their own equality. So let me see. It was a gay bar in the Village in New York City. So police attempted to raid the establishment. So the first March for Gay Rights was held in New York the following year to mark the anniversary of the riots, and gay pride marches now take place in dozens of cities across the country. No Supreme Court ruling or national legislation explicitly protected gay men and lesbians from discrimination until 1996. After losing the first gay rights case decided by the court, Bowers v. Hardwick, which is mentioned in Chapter 4, the gay rights movement brought test cases challenging local ordinances restricting the right to marry and allowing discrimination in employment, adoption, and parental rights. In 1996, and Romer v. Evans explicitly extended civil rights protections to gay men and lesbians by declaring unconstitutional a 1992 amendment to the Colorado State Constitution that prohibited local governments from passing ordinances to protect gay rights. Then in 2003 in Lawrence v. Texas, the court overturned Bowers and extended the right to privacy to sexual minorities. And if you look back and before I read the rest of this, see Lawrence v. Bauer. I want to read in more detail about what that case is. Let me see if I can find it without having to hunt too hard. Okay. Give me just a second, guys. Lawrence. Probably could have already found it by now, right? Give me just a second. I'm almost there. All right. Lawrence. 114. There we go. All right, so in Bowers v. Hardwick, the court ruled in favor of a state anti-sodomy law on the grounds that the federal constitution confers no fundamental right upon homosexuals to engage in sodomy. Hate to tell them that homosexuals are not the only ones who engage in sodomy. 17 years later, to almost everyone's surprise, in Lawrence v. Texas, the court overturned Bowers with a dramatic pronouncement that gay people are entitled to respect for their private lives. So this is the right to privacy thing for them. Wait, where did it go? As a matter of constitutional due process, and that the state cannot demean their existence or control their destiny by making their private sexual conduct a crime, which is what they were trying to do. I mean, what are you going to do? Like bust into people's homes who you know are gay and try and catch them in the act? Like, it's ridiculous. In 2015, the court took another important step in the protection of gay rights by declaring that state bans on same-sex marriage were unconstitutional because they violated the 14th Amendment's equal protection and due process clause. So there's that. So it says here, the Supreme Court's decision in Obergefell v. Hodges guaranteed same-sex couples the right to marry in all states and required states to recognize same-sex marriages performed in other jurisdictions. Gay rights advocate won a significant victory of a different kind in 2009 when new legislation extended the definition of hate crimes to include crimes motivated by hatred of gay and transgender people. In 2020, LGBTQIA and transgender individuals won a significant victory in the court in a 6-3 decision. The court ruled that the 1964 Civil Rights Amendment, or Act rather, prohibited employment discrimination based on sexual orientation, just as it prohibited employment discrimination based on race and gender. So, so those have been massive movements towards equality. If you listen to Clarence Thomas, these things should be reversed and gone back to the states, which would be a massive blow to the 14th Amendment being applied at the federal level. So I don't understand his thought process and how that wouldn't negatively impact all these other things that have been done under the 14th Amendment. So let's see. So this is on page 140, which talks about the same case. So let's see, we're almost done. We're in the very last section now. Explain the key Supreme Court decisions on affirmative action. So if you remember earlier on in the chapter, we talked about making sure that there were affirmative things that were put into place to end de jure segregation, de facto segregation, that sort of thing. So from that progression ended up coming of affirmative action procedures and rules to try to help further along disparities between sexes, between races, basically inequality. So affirmative action are government policies or programs that seek to redress past injustices against specified groups by making special efforts to provide members of those groups with access to educational and employment opportunities. Basically trying to equal the, level the playing field, because again, past discriminated groups are not starting out on the same footing as people who have not been discriminated against, right? If generationally your family has not had money because they have been kept from jobs, they've been kept from being able to buy land in a better place to be able to make themselves grow and progress and proceed up the ranks of the evolutionary chain, they're going to be further behind in what we as a society kind of view as success, right? Money and land ownership and decent jobs, et cetera, et cetera. So affirmative action tries to balance that out and make it more equitable. Okay. So there have been arguments about what level affirmative action should be done, how much we should do. In recent years, the Supreme Court has kind of pulled back on the extent of the level of appropriations to help with those grievances and those past injustices. And again, that also goes back to, how the Supreme Court is made up. So, so the slide asks, what's the appropriate level of judicial scrutiny in affirmative action cases? Who should bear the burden of proof? So in 1978, in the Regents of the University of California versus Bach, affirmative action was upheld and quotas and separate admissions for minorities were rejected, saying, okay, like that goes too far. Now you're doing like preferential treatment and we're just trying to get people up to like the same opportunity, but not like put them ahead of the game. So, let me find, let's see. Okay. Bach, a white male, brought suit against medical school of University of California on the grounds that in denying him admission, the school had discriminated against him on the basis of his race. So reverse racism, basically. That year, the school had reserved 16 of 100 admission slots for minority applicants. Bach argued that his grades and test scores ranked him well above many students who were accepted and that he had been rejected because he was white, where others were accepted because they were Black or Latino. The court ruled in his favor and ordered him admitted to the school. It stopped short of declaring affirmative action unconstitutional. It accepted the school's argument that achieving a diverse student body was a compelling public purpose, but found that the method of a rigid quota of admission slots assigned on the basis of race violated the 14th Amendment Equal Protection Clause. Thus, the court permitted universities and other schools and businesses to continue to consider minority status, but limited the use of quotas in situations in which, one, previous discrimination had been shown, and two, the quotas served more as a guideline than a precise ratio. So more as like a general guideline, but not like a hard and fast number that they had to hit. So it has continued to be ambiguous. The book gives other cases of that as well. For example, Grutter v. Bollinger in 2003. It was Michigan Law School was sued on the grounds that its admission policy discriminated against white applicants with equal or superior grades and scores on law board exams. They sided with the law school, saying that strict scrutiny to the policy, they found that it was tailored to a compelling state interest in diversity because it gave a highly individualized, holistic review of each applicant, in which race counted but was not used in a mechanical way. The court ruled that diversity in education is a compelling state interest and that racial categories can be used to serve that interest, put affirmative action on stronger constitutional ground. So it's all based on how affirmative action is used in each case as to whether or not it's okay or not. And again, these white students have a leg up because more than likely they come from parents with a higher education and more money and maybe a better in the town that they grew up in, et cetera, et cetera, et cetera. Not always, right? Like I'm not saying all poor people have a silver spoon in their mouth, right? We, a lot of us grew up poor, but we don't have the added burden of the color of our skin being a deterrent of success for us in our lives. So, and that does negatively impact things. And so that's where affirmative action helps to try and balance the scales. So Like before, make sure like you take a look at the what do you think on page 143. Always very helpful in kind of applying to what we've learned in the in the book to real life examples. And 144 and 145, the study guide, the keywords, as always with the chapter, very helpful additional study method in addition, or I'm sorry, and 146 and 147. So it goes over a little bit. So it's a great supplement in addition to the study guide that I always give you for the tests as well. So so now we're going to do the public opinion poll, which is so funny because the next chapter is public opinion. Sorry, it's probably not all that funny, but it's late, so it seemed funny in the moment. So public opinion question number 1. Do you believe the U.S. Transportation Security Administration, TSA, should be allowed to conduct ethnic profiling, or is this practice a threat to individual civil rights? So this is something that really picked up after 9/11, and people wearing a burqa, people wearing like headdress were were like pulled out of line and like had additional checks, and they were largely nitpicked in a way that other people were not when flying for several years. I know it's not quite as bad now, but it still happens more than someone else. In all the years of the flying that I've had my random number, I was pulled aside to do like a full body check once. And I'm sure minorities who fly regularly will say, oh, it's definitely been more than once. For me, this is always what I put it back to for everybody. Remember that a threat to anyone's civil liberties and civil rights is a threat to everyone's. At what point do they start discriminating against you because of the way you look? So, number 2, should states and the federal government be allowed to ask people they suspect of being an unauthorized immigrant based on physical appearance to prove their legal status? Same thing I just said before. People can look Hispanic, Latino, Muslim, Japanese, Chinese, and still be legal citizens of this country without justification, like true, like there's a tip that, or like not just a tip, because people will lie because they don't like somebody, but if there's evidence that they might be an illegal or unauthorized immigrant is much better than illegal immigrant. All of us are illegal immigrants unless we're 100% Native American. Like nobody started out here doing it the right way. So, but now again, you're racially profiling. So, so that's a problem. So just those 2 for public opinion polls. So that was nice and short. So this shows how different countries rank in gender equality. We don't rank that well. That right? That's not good. Out of 25 countries, like the top 25, we're number 19 in how well we rank. It's a problem. So, I mean, like, just look at all the states ahead of us. It's insane how low we are on the totem pole. So we got some learning to do still. We're still a very young country when you compare us to other countries and islands and things like that. And I think it shows in a lot of what we have done and continue to do to people. And there's like a level of immaturity, I think, in our society in the way that we see other people, that other countries have already kind of gone through those growing pains, if you will, that we are still in the middle of. So that is the end of the PowerPoint. therefore the end of chapter 5. So if you have any questions, as always, feel free to let me know. Hopefully you guys understood the material. Chapter 4 and 5, I find to be two of the most interesting in the book. Honestly, I love pretty much all of the chapters, but I find 4 and 5 to be so vitally important to understanding the foundation for everything else, and that without those things, nothing else matters, right? And then I also find the chapters on Congress, the presidency, and the federal court system to be so important to understand what they're supposed to be doing in their job, and why things are not as black and white in politics and government as people assume they are. And then the next chapters that we're going to talk about with public opinion and the media, while a lot of people would say, oh, it's not as important to government, it really is, because public opinion helps our officials to figure out what direction they need to head in that are important to their constituents. And then for the media, like they're generally speaking the truth tellers, and they call things out that's so important that some other countries don't have that, right? Like Russia gets whatever the Russian government feeds their citizens, that's the truth, even though it's not, right? Like they're told whatever the government wants them to believe, and they are cut off from the rest of the world to know the truth. And we don't have that here. It's just another level of our freedoms with the Bill of Rights. And the freedom of the press is so vitally important in the First Amendment. And so we'll be talking about that in the next 2 chapters. So let me know, as always, if you have any questions, if you need anything, and we'll talk soon. Bye.